Okay, imagine this. Two professional men in Australia, both earning, massive salaries.
Mm.
And both of them were recently terminated from their jobs for getting into a physical fight.
Right.
But when their cases actually went before the authorities, the results were, well, they were like night and day.
Completely different worlds.
On one side, you have Leonard dissect. He's a senior partner at EY, earning a reported $1.35 million.
Wow.
His fight. It happened late at night in a really expensive bar in Sydney. Then on the other side, we've got Greg Davis. He's a fly-in, fly-out mine operator in his 60s. And his scuffle was over dust and driving speed in a remote parking lot in Western Australia.
So a huge contrast right from the start.
Exactly. Both men lost their jobs. But the big question we're looking at is how the Australian workplace relations system treated these two cases in 2025.
Mm.
What does the Fair Work Act really prioritize? Is it the misconduct itself, or is it the process the employer followed?
That's the million-dollar question, isn't it?
It is. We've pulled together some really fascinating material on these two cases, using detailed reports from the ACT Supreme Court and the Fair Work Commission, and also insights from specialized non-lawyer workplace relations firms. Our mission today is to cut through all the legal jargon and figure out what actually defines serious misconduct, especially when a huge corporate reputation is on the line versus when it's just about basic fairness. Okay, let's unpack this.
It's so important for you to understand that the Australian system, while it's all under federal law, it's applied entirely based on the context.
Right.
And these two cases perfectly illustrate that split. You have one case decided almost purely on a contract and reputation, and the other decided almost entirely on the employer's, well, their procedural mistakes.
So it's not just what you did, but how your boss handled it afterwards.
Precisely.
Yeah.
It all depends on how carefully your employer acted after the incident.
That context brings us to the vast majority of Australian employees. People who don't have $1 million salary and lawyers on speed dial. This is where specialized, non-lawyer workplace relations representatives come into play.
Yes, and our sources really highlight the role of organizations like AWDR. They're actually Australia's leading specialists in this field.
And the reason they're needed is what? People just don't know their rights.
That's a huge part of it. The fact is, many employees simply aren't aware of the protections they have under the Fair Work Act or equal opportunity laws. So these specialist firms, they step into that knowledge gap. They've been at this for over 30 years, helping, I think, something like 16,000 clients navigate these really confusing processes.
And it's not just about getting fired, right? The scope of what they handle is huge.
Oh, absolutely.
I mean, we're talking unfair dismissal, general protection disputes, sexual harassment. Even these really nuanced things like non-genuine redundancy, where a company just wants to get rid of someone.
Or constructive dismissal. That's a big one. It's where the workplace becomes so toxic, so hostile, that you're essentially forced to quit.
And it's important to be clear here. Our sources stress that they are not lawyers. They don't give legal advice.
That's a key distinction, yes. They are workplace relations specialists. They offer assistance with negotiation, mediation, representation, all across the country. They provide that crucial guidance and strategy to get some kind of justice or closure for the worker.
And for some claims, like unfair dismissal, they even offer no-win, no-fee services.
Which is a game changer. It just dramatically lowers the barrier for someone who is already struggling financially after losing their job.
So when we talk about serious misconduct, it's not always a punch up in a car park.
Not at all. The source material points to really complex stuff like adverse actions.
Which is when you're fired for exercising a workplace.
Yeah, exactly. Like joining a union or raising a safety concern, or you have disputes over abandonment of employment. The common thread in all of this, and the absolute core issue in one of our cases today, is procedural fairness.
So even the company's own internal investigation has to follow the rules.
It has to. It must stick to standards set by awards, agreements, contracts. And these specialist firms often provide support during those investigations just to make sure the employee's side is heard and the process is correct. Because if that process is flawed, a clear case of misconduct can just fall apart.
And that's what we see in the mine workers case.
Powerfully so.
Okay, before we get to that procedural failure, let's talk about the failure of reputation. Case study 1, Leonard dissect versus EY. This is the story of that senior partner earning $1.35 million plus a bonus.
And crucially, bound by a comprehensive agreement that linked his personal behavior directly to the firm's global code of conduct. A position like that, it demands. Well, it's not just about doing good work. It's about impeccable public conduct.
Because the brand rests on people like him.
The entire global brand.
And the trouble started pretty early. Incident 1 was back in May 2022. It was a Miami Vice-themed Christmas party.
Of course it was.
Nacita was accused of propositioning a colleague, allegedly saying he wanted to sleep with her, making comments about having affairs with married women.
The details that came out in court were just fascinating. He disputed the propositioning part, but he admitted to saying he had probably been with more married women than other single women.
Regardless of what he meant, EY saw it as a massive breach. The result was stunning. He got a first and final warning, mandatory training, and a $52,000 financial penalty.
$52,000.
Just think about that. A huge firm publicly fining a senior executive 4% of his salary for something he did at a Christmas party. It tells you immediately how serious they were about setting new boundaries.
The country manager basically told him, if this happens again, you're gone. And that penalty wasn't just a punishment. It established a clear, documented history. It set the stage for what came next.
Okay, here's where it gets really interesting. About 15 months later, August 2023, Incident 2. Nacita's off the clock at a fancy Sydney bar, arguing with the manager over a lost jacket.
A lost jacket.
CCTV footage captures him physically pushing and bumping the bar manager. He was later charged with common assault by the police.
So EY sees the CCTV footage.
And they moved to terminate him immediately for just cause. They cited the fight, obviously, but also his failure to tell them about the criminal charge, which he's required to do.
Right.
Now wait, if the writing was on the wall, why didn't he just resign? He actually tried. He emailed his notice of retirement right after it happened. Why couldn't EY just accept that and let him disappear quietly?
Because their partnership agreement gave them what's called absolute discretion to remove a partner for conduct that equates to a just cause. If they'd accepted his resignation, it could have looked like they were okay with the behavior.
Or that it wasn't that serious.
Exactly. By rejecting his retirement and terminating him on the spot, they sent a very clear message.
So Nacita challenges this in the ACT Supreme Court. His argument is that the misconduct happened in his private life, and the decision to fire him was, unreasonable, especially since he'd already tried to retire.
And this is the absolute core of the case. EY argued that just cause wasn't limited to his performance at work. They said it extended to any conduct that significantly harmed the firm's interests.
And the Supreme Court.
The Supreme Court agreed completely. They said it was clearly reasonably open for the country manager to conclude that his actions were likely to harm significantly the firm's reputation.
Especially with that prior warning hanging over him.
Yes. And crucially, the court also looked at the external pressures on EY at the time. There was an independent review into their own workplace culture, a high-profile parliamentary inquiry into misconduct at major accounting firms.
So bad timing for him.
Terrible timing. The judge recognized that Nacita's behavior, once it became public, directly undermined everything the firm was trying to do publicly to fix its image. The ruling was clear. The termination was justified. For highly paid partners, your workplace can follow you home if your actions hurt the brand.
And the final result. The court dismissed his case, and he was ordered to pay EY's legal costs. It's just a stark example of how reputation can be the most unforgiving clause in a corporate contract.
It really is.
Okay, now let's travel thousands of kilometers away and drop the dollar value.
Right.
A lot. Case study 2. Greg Davis, the mine operator, versus Odell Resources. We're moving from the Supreme Court to the Fair Work Commission.
A very different world. This is Greg Davis, a fly-in, fly-out worker in his 60s. He operates heavy machinery in remote Western Australia, but he lives in Queensland.
Quite the commute.
A huge commute. The incident happened in September 2024. It was a dispute in the employee parking lot after a night shift, apparently over a colleague driving too fast and kicking up dust.
The stories are completely different, which is where it gets messy. Davis claimed he approached the other guy calmly, but his colleague, Paul Tsoukalos, became aggressive. Davis said he tried to de-escalate. He counted to 3, stepped back, but then reacted when he thought Tsoukalos was about to hit him.
And another colleague actually backed that up, saying the younger worker dropped his arm like he was going to throw an uppercut.
Tsoukalos' version was way more dramatic. He claimed Davis just punched him without provocation, put him in a terrifying chokehold, and dragged him. So clearly a fight happened.
No doubt about that.
So after the incident, Davis was stood down. And then came what can only be described as a procedural nightmare. He had to travel home a 35-hour journey at his own expense.
35 hours.
While he's still exhausted from that, he gets a show cause letter with the allegations. He asks for a bit more time to respond, citing the travel and, being completely wiped out.
Which seems reasonable.
You'd think so. The company denied the extension, and then they fired him for serious misconduct fighting by email.
Wow. And this is where the Fair Work Commission steps in. They first had to look at whether there was a valid reason for the dismissal.
Now, was there?
Well, yes and no. The FWC accepted that Davis threw a punch in what he thought was self-defense, but they ruled that holding the chokehold for too long was excessive force.
Okay, so the FWC found there was a valid reason to dismiss him. He used excessive force. So if the reason was valid, why did they even intervene? Why should a bad travel schedule cancel out a firing for fighting?
Because under the Fair Work Act, procedural fairness is everything. It's the backbone of a lawful termination. It's not enough for the employer to be right about the misconduct. They also have to give the employee every reasonable chance to explain themselves.
I see.
So the FWC acknowledged the valid reason, but they found that refusing to grant that time extension, given the extreme 35-hour travel ordeal he'd just been through, was fundamentally unreasonable and unfair.
That's a powerful statement. The FWC is basically saying the employer's failure to follow a fair process was a bigger problem than the employee's physical misconduct.
Precisely. The procedural failures outweighed the seriousness of the misconduct. They concluded the dismissal was unjust. Now, reinstatement was denied because, there was fighting and excessive force, but compensation was awarded.
But there was another catch, right?
Yes. The commission also factored in that Davis had a hand in starting the confrontation, so they reduced the final compensation by 20%.
That 20% reduction shows they were really trying to balance it. The employer's mistake versus the employee's role in the fight. So the final payout.
It came to $2,890.08.
A tiny fraction of the EY partner's salary.
A tiny fraction. But the principle behind that small number is monumental. Even in cases of serious misconduct, you have to follow due process or the employer will lose. Failing to grant a reasonable extension to an exhausted worker was the fatal flaw.
This has been an incredible deep dive, really showcasing the two extremes of Australian workplace disputes. We've seen how misconduct is viewed through just entirely different lenses.
Absolutely. Nasita, the corporate partner, was judged on his image. His termination hinged on those just cause provisions that bled into his private life, all driven by the firm's need to protect its brand.
And the law actually supported that, acknowledging the external pressures in his history. On the other hand, you have Davis, the mine worker. Despite using excessive force in a fight, he ultimately won his case. Why? Because his employer failed to uphold the most basic standard of procedural fairness.
The simple act of denying a reasonable time extension became the company's downfall in the eyes of the Fair Work Commission. And this just highlights the critical service provided by those specialist representatives we talked about earlier.
Right.
They bridge that gap for the average worker. They make sure those procedural obligations, the right to respond, the right to due consideration, are rigorously enforced. They provide the strategic guidance needed to navigate the strict deadlines and the technical side of the Fair Work system, whether it's a dispute over discrimination, redundancy, or whatever else. Time is always critical.
So this journey has taken us from the swanky bars of Sydney to the dusty, remote mine sites of Western Australia. It shows how money, contract, and reputation can define one outcome, while exhaustion and process define another.
A perfect summary.
The EY case proved that for senior corporate roles, the definition of workplace behavior is elastic. It can follow you all the way home, justified by the immense reputational harm you can cause. But the mine workers case shows that no matter how clear the misconduct seems, an employer's failure to respect due process can turn a justified termination into an unfair one. So for you, the question remains, when does an employer's right to protect its reputation outweigh an individual's right to a fair hearing? And are the systems designed to ensure that fairness applied equally to everyone, from the millionaire partner to the FIFA worker?